What's up, everyone, and welcome to the Long Game Podcast hosted by Thomas Kopelman and Jacob Turner. In each episode, you'll hear us break down financial topics that are relevant to you and your situation. Our goal is to help bring credible financial information to you in short, bite-sized episodes.
All opinions expressed on this show are for educational, informational, and entertainment purposes only. Nothing on the Long Game Podcast should be considered advice. Always consult with your team of professionals before making any decisions regarding your finances.
All right, what is up, and welcome back, everyone, to another episode of the Long Game Podcast. I'm your co-host, Thomas Kopelman, here with me, Jacob Turner, and today we have Dave Haughton on. If you didn't know, Dave and I actually have been hosting another podcast together with wealth.com. It's called The Practical Planner. We've done a ton of episodes together now, but I thought it made a lot of sense to bring him on. So a little bit about Dave. He has this interesting mix where he's been an estate planning attorney, then he's worked at an RIA kind of helping on estate planning for the clients that they have, and now he works at wealth.com as, kind of, I don't even know necessarily how to describe the role, but we have attorneys inside of the platform. You're not the one to hire, but you're helping kind of consult on documents and hiring advisors or veteran in each state, all of the above. But Dave knows a ton, and he's a great resource because there's very few estate planning attorneys that have really worked in this RIA side of things to understand financial planning. So we thought would make sense is bringing him on, and we're going to do a two-part series. So part one today is really going to be about estate planning for business owners, kind of the 101 side of things. What are the basics? What do you need to know? What are the important things to get done and why? And then part two is going to go in for, a lot of Jacob and I's clients are business owners that are scaling, plan to sell down the line. And so estate taxes are a big part of the planning. And so we're going to go through a lot of these complex tax structures. The goal is that we're going to hit on each one, kind of the value of it. We're not going to go into every rule, stipulation, downside, but that's going to be it. So Dave, thanks for joining us. Anything else you want to add about who you are?
No, thanks for having me. No, you hit it. You hit it well. I started out as an estate planning attorney, moved over to RIA broker dealer, was a consultant for advisors. So both sides of the fence, and it's been enlightening, very enlightening to go from seeing the dynamic between advisors and estate planning attorneys when I was an attorney to the dynamic now and trying to bring them together.
Yeah, which is obviously the goal, right? You want both people on the same team working together to make sure that everything goes well and you pay the least amount of taxes over your lifetime. So let's just start the conversation on estate planning for business owners. Like when that comes to your mind, what do you initially think of? Because every time I come across a business owner, they do not have any basic estate planning documents done. And I don't know if that's what you typically have seen as well.
Yeah, absolutely. I mean, you have to start with the basics always, because if, there's an estate planning, especially maybe more so than anything else, there's a paralysis of analysis and people just kick the can down the road and don't get the plan done. And when you have something like a business with all the complexities to it, trying to determine what the succession is going to be, you can get bogged down in the details and can prevent you from getting an overall plan in place because you have so many complex things to deal with. But first of all, just super important, just get a plan in place. Revocable trust, will, powers of attorney. Make it so that business isn't stuck if you become incapacitated, if you pass away. It may not be the perfect plan. You may need to do additional tax planning or additional succession planning. But so long as you at least have that basis, the basic estate plan in place, now you can build off of that, and there won't be a disaster. If you become incapacitated or you pass away, you at least have something in place.
Yeah. And when you think basics, like what is the initial starting point that people need to be aware of?
Well, I mean, you need to start with a revocable trust, I think, in almost all circumstances. Some people don't feel the need for a revocable trust. They'll just use a will, but, there's no downside to a revocable trust. And it doesn't matter your net worth, the complexity of your assets. It almost always makes sense to have a revocable trust in place that's going to avoid probate, and it's going to have a timely and orderly transition of assets to the next generation or to a spouse. The power of attorney for finances is incredibly important because the trust sometimes can't handle everything. Some businesses you can't put into the revocable trust, right? There's licensing issues. And then, IRAs, retirement accounts, you can't put into a trust. So you need to make sure that you have a power of attorney in place to have someone who's going to be able to seamlessly step into your shoes and access your assets on your behalf and do what you could have done with them. And then with that, you need a pour of a will and then healthcare documents to make sure people can make healthcare decisions. Once you have those in place, you know that you can say, I have an estate plan and build off of it.
I think one thing, Dave, you mentioned the idea of making sure everybody has a plan. And one of my favorite lines from this estate planning attorney that we partner with a lot is everybody has a plan. It's either the government's plan or one that you set out, right? And with estate planning, ultimately, you're just creating that plan for the inevitable day that something happens. And I know nobody wants to think about this. Everybody thinks we're going to live forever. Our businesses are going to go on forever. But we know that's not the case. And I think one of the things that holds people back oftentimes is estate planning has been this really clunky process. And Thomas, I know you're part of the team at Wealth. We use Wealth in our business. Dave, I know you're part of the team at Wealth. I'm curious to see and hear what your perspective is for somebody that's listening that's thinking, man, estate planning, like, I don't even know where to start, like revocable trust, like just sounds so complicated. How have you seen the dynamics of actually getting some of these core estate planning documents in place?
Well, I mean, I think what brings a person to start to do estate planning, there's usually some specific impetus for it. So either they're going on vacation and they're worried, what if something happens when I'm overseas? They had a recent death in the family and they might have saw a mess that occurred and they realized that they need to have it in place. I dislike that that's where you need to be at in life in order to take that step. So I think, a big part of it is just getting the word out. I think what's awesome about Wealth, and it's one of the reasons I joined, is because of the impact it can make, because it's just so scalable of the thousands of estate plans we get in place. I know there's a statistic out there that I think only 27% of people in America have an estate plan. So, attorneys are still necessary, certainly, for the formulation of estate plans. But 63%, 73% of the country needs an estate plan, and the only way to get that done is to make it more available, more accessible. And so, if you can make it more scalable, make it easier for the client to access the estate plan without needing, like you said, the clunky process of you need to go to the attorney's office, get them all the paperwork, then it gets prepared, and then you go in for the signing meeting, then maybe you go in for another meeting for the funding. This is all stuff that, it's the easiest thing to put off, obviously, because it's not going to matter literally until you passed away or you're incapacitated. So it's the easiest thing to put off. And, there's also the thought that, you're having someone pack your parachute. So, who are you going to choose? What decisions are you going to make? These are all things that cause the paralysis of analysis. But like you said, if you don't have a plan in place that you chose, then the government's going to choose for you. And a lot of times that's not going to work out in your favor. So I think it's really just about motivating people, trying to get the word out and making it as easy and accessible to them as possible.
Totally. And I think, going back to what you were talking about before on like pretty much everybody needs a trust. I want to dig more into that because that's something in my mind. I believe, obviously, I can't like give that advice to anybody as a non-attorney, but I think there are situations where you don't need one, right? And there are like if you don't own a business, you don't own real estate in different states, and you live in a state where probate is really basic, and you basically put on like TOD or POD designations on different accounts. Like maybe in those situations you can, but obviously if you're listening to this podcast, most of you are kind of the ideal type of people that Jacob and I work with. So, you own businesses, you're very high income, you probably own real estate in different states. You have kids who are under 18. And so I'd love for you to kind of go a little bit deeper on like why a will is probably not enough for this type of person.
Yeah, absolutely. Yeah. And you're right. There are circumstances. I live in Massachusetts and I practice in Massachusetts, which is a nightmare for probates. Yep. So nobody's going to say, it's easy here, but there are certainly states that the process isn't as bad for probate. So avoiding probate purely as the only reason to form a trust, sometimes, that doesn't need to be the priority. But a lot of people think, well, I can put TOD on all my assets. I can put a beneficiary designation. And so I can avoid probate by myself without necessarily needing the documents in place. And anything that doesn't go through TOD can go through the will, and that's a pretty simple process. There's something that some people don't think about, especially if they have investment accounts. And that's that if you become incapacitated and you have assets in your name alone, you're going to need a power of attorney in order for the person to access those assets. And banks are notoriously hesitant to want to honor powers of attorney if they don't have to, because obviously there's a lot of elder abuse going on. There's valid reasons why they're hesitant to accept powers of attorney. So there's a lot of scrutiny. It goes to the legal department, and there's some risk that it doesn't get accepted or it gets delayed when someone really needed access to the assets. So that's another reason why a trust is really great, because I'm sure you've seen, changing a trustee on a trust is a pretty simple process, and you usually don't get a lot of pushback from the financial institution, whereas putting a power of attorney maybe could cause a little bit more of an issue. So that's one. The second thing, of course, tax planning. So estate tax planning, you can do it through a will, but it's just so much better administratively and less costly if you can do that tax planning through a trust. And, the exemption's really, really high right now. So a lot of people don't necessarily need to do the estate tax planning right now, but you want to at least have that option. Let's say your state institutes a state estate tax or has one, you move to a state with a state estate tax, or, we're potentially going to see the sunset of the Tax Cuts and Jobs Act. So that exemption's coming way down. You want to at least have something flexible in place to be able to do the tax planning. And a lot of times the trust is the best instrument for that.
Yeah, one point you made there that I think is really important for people to understand is we often think about estate planning as this concept that you do later in life. But the reality is when you turn 18 and you're a legal adult, you all of a sudden now have all these decisions you have to make. And even for us, when we're thinking about an athlete that turned 18 that comes into money and we start talking about estate planning, usually the parents or the kids say, well, I don't know if that's really for me. Or even a young entrepreneur saying, I don't have a ton of complexity going on. I'm just going to put TODs on my accounts and beneficiaries and I'll be fine. But I just can't stress enough how important it is to make sure that you have power of attorney somewhere, and then you make sure you have a healthcare directive in place, because look, these situations come up, and the reality is, like, you don't want to be in a situation where at the last minute you're trying to formulate this and put all this stuff in place, because the reality is, if you don't do it at 18, you're probably not going to want to do it at 30. You're not going to want to do it at 40. You're not going to want to do it at 50. And this is where I think even having that advisory relationship comes into play so much, because oftentimes, and Dave, I'm sure you can speak to this from the attorney side, it's very hard to get in front of some of the clients and be able to say, like, hey, you really need to get these documents done, versus, if somebody's working alongside Thomas or myself, this is part of our process. Like, do we have this in place? If we don't have this in place, we're going to honestly probably be somewhat of a pest until we get it in place, because we know how important it is.
Absolutely. Yeah. I saw a statistic that I think 90% of advisors' clients consider estate planning to be critical, and they want their advisor to be involved with the estate planning process. And it's just not always the case. So they think it's critical, but they don't get across the finish line for whatever reason. And I think the advisor plays such a critical role. And I saw it all the time when I was practicing, but then more so when I moved over to the RIA space, because the advisor just is with the client and knows a lot more about the client than the attorney ever will. The attorney, they'll do a 1-hour consultation, and you don't know in that time, are they really going to find really, what the pain is for why they need the estate plan? Are they going to know the family dynamics to really motivate that client to get across the finish line? I think the advisor is in a way better position for that. And you spoke to, stages of life. The advisor can even help the client get their children to get an estate plan in place. A lot of times by the second generation, those clients are leaving, up to 90% are leaving the advisor, the client's children, usually because they don't even have a relationship in place. If the advisor is also helping the client to get their estate plan in place, to protect the children, but then also help the children to get their own plan in place, even if they're not a client yet. Now you're building that relationship and you're providing a lot of value because, like you said, doesn't matter your age. If you're 18 years old, you need a healthcare proxy. Even if you don't have a lot of assets. If you turn 30 and you start having children and you don't have a lot of assets, you still need a will to name guardians for your children. And then as you start accumulating wealth, that's when more of the tax planning and things come up. But yeah, just critical that clients are motivated, and I think the advisor is the best source for that.
Totally. And I looked up the statistics. I remember seeing the one you said, and it's 92% want it from their financial advisor. But the more important one that I was trying to find is that, you're talking earlier about reasons people get their estate plan done. And I found that the number one reason people get their estate plan done is because of their financial advisor, not even a life event. And so they looked back and it's like 70% of people with an estate plan got there because of being pushed from their financial advisor. And that's like 70% of the 26%. So just shows that very few people are being proactive in doing this without that kind of being the center point. The other thing I do want to go back to is, in the beginning you were talking about, why a will is not enough. And I think a lot of business owners don't understand that the reason why a will is not enough has a lot to do with what you were talking about before, right? If I'm a solo business owner, I own my business, there's some reason I get in a car accident, I'm overseas, something needs to happen in my business. A lot of times banks, custodians, other places are not going to take this power of attorney and say, great, yep, you can go pay this check, or you can take this money, you can do whatever. They're going to say, nope, it's not approved. But if you have your business owned by the trust, and in the trust you have a designated person who can make decisions about your business, it is a lot more likely. I mean, I haven't seen any issues of that being approved. And so to me, that's the number one reason why a business owner does need a trust over just a basic will.
Absolutely. 100%.
I think the one other one we didn't talk about here too is a lot of people own real estate in different states. So, if we're talking about probate avoidance in your main state, now imagine you live in Florida, you have a home in Colorado and maybe a home in California. And now your executor is like, great, I'm going through probate 3 different times, all because you didn't set up one trust and change the ownership of those properties to the trust.
Absolutely. I've seen it countless times in practice. And those were big money makers as far as legal fees, because there was so much paperwork, so much coordination. Usually, someone died in Massachusetts where my client, now they need a probate in Florida as well. So we got to reach out to a Florida attorney because the Massachusetts attorney can't handle that. So now you have a separate attorney, separate retainer. It starts to get costly just in the administration when that comes up, dealing with all different laws. So you put it in a trust. Any property from any state, pretty much, as far as I know, can go into the same revocable trust. Even if it's, there's a property from Florida and there's a property from Massachusetts, you can title them both into the same revocable trust. You don't necessarily need 2 trusts. So it just makes things so much simpler.
Yeah, two things I want to point out there too is this is an investment. I mean, when we think about the cost of potentially having an estate plan done, you obviously have the financial cost that it could potentially cost you, but you also have the time cost of collecting documents, going to meetings, making sure that it's done the right way. But this is truly an investment because at some point, these situations are going to come up, and you can either invest in it now and probably pay less money and spend less time and energy and effort, or somebody else down the road is going to pay a lot of money and spend a lot of time, energy, and effort that goes into it. That's where I just think this is such an important concept for people to understand. And the other thing I want to point out is all these documents that we're talking about right now, revocable living trusts, these can all be changed. I think this is one of the most common misconceptions that I see. The first time I bring up a trust, people kind of get guarded. They think, okay, well, if I make this decision today, can I change it? Do I have access to the money? And everything that we're talking about here, you have the exact same access to it as you would if it was titled in your individual name. All it is you are building a plan in place. And the analogy that I use is we're building the parking garage around your assets. And if they ever leave, there's an attendant there that says, hey, they wanted this money to go here and they wanted this money to go there. But you can always change it. You can always go in the parking garage and make changes to that plan. And I think that's an important thing for people to understand because that's such a common misconception that I run across.
Yeah, I agree. I mean, it's a lot of times people don't get a plan in place because they want the perfect plan and they can't make a decision. There were times I remember that people wouldn't, you do the consultation, and they'd be ready to do an estate plan. You'd be going through the decisions. And one of the decisions they had to make is, okay, well, what happens if, say you have 3 children. What happens if all your children have passed away and they don't have any kids? And they're like, oh, geez, I don't know. The most unlikely scenario you could possibly think of. They'd say, oh, geez, I don't know. And, you can't get them to call you back because they've got paralysis of analysis for that one decision. But, would you rather have a plan in place that you can change later, or no plan and have the state decide for you? So, yeah. And I mean, this comes up in every way. I mean, I think having a flexible estate plan is really important. Obviously, these basic documents we're talking about, they're all completely rewritable really at any time prior to incapacity. And that's why I call them standby devices, or a revocable trust. I call a standby device, because it shouldn't impact your daily life at all while you have it, but it's standing by for when something bad happens. And I think when you form your estate plan, you should assume that something's going to happen tomorrow, and you're okay with it if something happens tomorrow. But 2 years down the line, 3 years down the line, something changes. It's easily amendable.
Agreed. One last thing I want to talk about in this episode is real estate with trust, right? We already talked about the need and helping with probate, but like one thing that comes up all the time is like, okay, well, you have a bunch of, at least I see this time, they have a bunch of rentals in their own name. And we all know, like, maybe part of this conversation is still asset protection, right? So like the less equity you have in the name, better. Maybe you still need these and you don't want to put them in irrevocable trust, which we'll talk about in the next episode. But, when you have everything in your own name, they can come after all the equity in your rentals. They can come after your investment accounts. They minus your 401ks and ones of protection. They come after your bank accounts. And so you bring up, okay, great. Well, it's probably a really good time to move your real estate into something like an LLC. That's the most common, but people say, well, what if I can't do that? Right. And I'm curious from you, I have my own experience. Like, do you see most often that people are able to end up moving these properties into LLCs for good asset protection purposes?
Yeah, I think absolutely. If it's a business related property, I think it should go into an LLC in a lot of circumstances, because there's not only protection from your personal assets if something happens on the property, there's actually protection of the property if something happens to you personally that people aren't going to be able to get at the LLC asset. It's called inside or outside protection. So the inside protection is something happens on the property, related to the property. Let's say there's a slip and fall, make it easy. You get sued. Really, the only thing they're going to be able to get to is the property itself, because that's all that's in the LLC. If you something happens at your home that's not inside the LLC, let's say, and they sue you and they're trying to gain access to your assets and something's in the LLC, all that they can get is what's called a charging order for the judge to say, all right, any distributions that come out of that LLC have to be forwarded to the creditor. And so what's the person going to do? They're just not going to make distributions from the LLC. So LLCs have a lot of power, actually, with protections both ways. And then you can turn around and you can just have the revocable trust own the LLC to make sure that everything flows the way that you're looking to do it. So I think, yeah, really great. And, that's actually a part of my background that I don't talk about very often, but I was actually a bankruptcy attorney for a couple of years at the very beginning of my career. And, you see the lack of protection in these decisions that people made without thinking that something bad could happen. And then, the financial crisis happened. And there was a lot of ways, even with estate planning, even making it flexible, that they could have protected more assets that didn't have to, go to the creditors.
Yeah. No, I couldn't agree more. It's just something that comes up all the time. And so like, both protection sides, I think that's a really important point. I think, some people have the hesitation like, oh, what if my mortgage company doesn't let me switch? And like, in my experience, I've only seen that happen one time. Every other time the mortgage companies have been fine. If you own rentals outright in cash, it's really easy, right? Like you don't have to just change the mortgage. I think step one is make sure they're okay with it before you go and move the ownership, because they could call the loan technically if you do that. But most times it's fine if you don't have a mortgage on it. Again, you just need an attorney to do a deed transfer. The other thing that people don't think about is one LLC for 50 rentals is also not a great thing to do either, right? The same idea of lots of equity, lots to, be able to go after. You don't want to have $10 million of equity inside of one LLC for the same reason. And, there's a lot of estate planning attorneys will say, one property per LLC, and that's probably the most buttoned up approach. In reality, with all of the added fees and tax returns, et cetera, many don't do that. And so maybe you come up with something for you, maybe it's 500,000 of equity, $1 million of equity, a couple million of equity, depending on your wealth level. But segmenting those out again for even more asset protection and then having the right commercial umbrella, et cetera, is super important.
Yeah, incredibly important. And I think one thing I want to bring up too, because some people think about that, what you were saying, when it comes to transferring a property to a trust, if it's in a mortgage. If you're transferring a property, this is aside from the LLC issue, but it's the same concept because people get concerned about this. If you're transferring a property to a revocable trust, they can't call the note on you. There's something called the Garn-St. Germain Act that if you're transferring in your family or to a revocable trust, they really can't call the note. Obviously, every situation is different in how people have loans and hold their property. So I don't want to say it's always the case, but there is a law out there to protect against it. The only time it can become an issue is if you refinance. Sometimes the bank will just make you take it out so that you can refinance and then you can put it right back in. So usually that issue, even with LLCs, like you were saying, the banks just want the money, and they're not going to call the note if you're paying your mortgage, because there's certainly no economic benefit to them to foreclose if they're getting paid the note.
Because I did come across it once from a client who wasn't working with us. It was like way afterwards. And they were like, oh, I reached out. And I think the issue for them maybe was they had a primary mortgage that they turned into a rental that then they found out was a rental. And then I don't know. So that's really interesting. It's good to know because people do.
Yeah. So that's a good point is there are parameters for what's the type of use of the property and how heavily is it occupied, as to whether it fits within that Garn-St. Germain. So primary residence, you're pretty safe. But when you get into business properties, that's when it's something to think about. But I rarely ever think that the bank is going to object to that.
Totally. But that's really good to know, because I didn't know that was like, there's probably some bankers who are like, nope, don't do that because of this. And you can now cite that, hey, no, you're wrong. Like, this is actually an okay thing. Cite exactly what you just said and you're good to go.
Absolutely.
Okay, cool. Well, I feel like we probably hit on everything we needed to for kind of this one-on-one episode. So everybody, we really appreciate you listening. Please rate and subscribe and tune back in next week for part 2, where we're going to get into all of the fun, advanced tax and estate planning for business owners.